hello from the great state of Virginia, and Mr. Bozeman and members of the committee. Thank you for this opportunity to testify today on H.R. 2696, the Servicemembers Rights Protection Act. I also want to thank Representative Walter Jones for working with me on this issue. He has been a tireless advocate for our service members and veterans, and I appreciate his efforts. Congress has long recognized the need for legislation to protect service members who face special burdens when trying to meet their financial and legal obligations while serving our country. Congress passed temporary legislation during the Civil War and again during World War I. And in 1940, Congress passed permanent legislation, the Soldiers and Sailors Civil Relief Act. In 2003, Congress updated that legislation and passed the Service Members Civil Relief Act, or SCRA. The Act temporarily suspends certain judicial and administrative proceedings and transactions that may harm a service member's legal rights during their active duty. The bill does not extinguish or diminish any rights anyone has against a service member, but legal proceedings are put on hold until a service member can have a fair chance to defend their rights in the legal proceedings. The SCRA provides for penalties for violations, but it does not expressly state whether service members have a private cause of action, whether they can bring a lawsuit on their own behalf for violation of the Act. Most courts have recognized the inherent right of service members to bring suit for a violation of their rights under SCRA, but a couple of recent court decisions have questioned whether the Act does grant service members a private cause of action. In Beatty versus Subway Real Estate Corp., a service member alleged that the defendants had violated his rights when they evicted him from 2 commercial spaces while he was deployed in Afghanistan. In Hurley v. Deutsche Bank Trust Company, a service member sued the defendants after they foreclosed on him and evicted his family, sold his home, all while he was deployed in Iraq. The initial ruling in both of those cases was that the service members did not have a right to act on their own to vindicate their rights under the statute because there was not expressly such a right in the bill, in the legislation itself. The initial ruling in both cases were overturned on appeal, but only after the service members and their families had to go through prolonged legal uncertainty and considerable expense. And there remains uncertainty in other jurisdictions, other circuits around the country. Congressman Jones and I introduced H.R. 2696, the Servicemembers Rights Protection Act, to end any question about a right of action for service members. The legislation would authorize an Attorney General, the Attorney General, to file a civil action for violation of the SCRA and allow the service member to join in that civil action brought by the Attorney General. But more important, the legislation provides that service members have their own private cause of action, regardless of any action taken by the Attorney General. There have been efforts in the past to strengthen enforcement of provisions of the SCRA for specific kinds of contracts. Those efforts are worthwhile, but they are a piecemeal approach to strengthening the SCRA and leaves open the possibility that some contract, some proceeding will be left out, and a service member will be left without any legal recourse. The SCRA is a comprehensive statute protecting the rights of service members. The remedies under the statute should be comprehensive too. We need a comprehensive approach that will ensure enforcement provisions for all actions brought to enforce the SCRA. The Servicemembers Rights Protection Act does that. In February 2009, the American Bar Association unanimously adopted a resolution proposed by the ABA's Standing Committee on Legal Assistance for Military Personnel that recommended an unambiguous authority for a private right of action, what this bill does. Further, in his statement before the House and Senate Veterans Affairs Committees on March 12, 2009, Colonel Robert F. Norton, Deputy Director of Government Relations of MOA, stated that MOA, M-O-A-A, recommends that the committees amend the SCRA to clarify that a private cause of action, a private right of action, exists under the SCRA, authorizing a service member or dependent to file suit. The Department of Defense has also vetted the language in this legislation. Our service members should be given the right, the opportunity to devote their entire energies to the defense of the nation when they are deployed. They should not have to worry about whether their homes are being foreclosed, their rights are being prejudiced, their families are being evicted because they are deployed in the service of our country. A right that cannot be enforced is no right at all. A right without a remedy is no right at all. The SCRA should have real teeth or it is meaningless. Denying individuals a private right of action to enforce their rights under the SCRA threatens the readiness of our armed forces and is fundamentally unfair. Thank you again for allowing me the chance to testify on this bill.
Thank you, Mr. Miller and Mr. Jones, for your advocacy on this. Mr. Loebsack, you're now recognized.
Thank you, Chairman Perriello and Ranking Member Bozeman, members of the committee. Thank you for inviting me